Huge breaking news. A federal judge in Delaware, literally an hour ago, issued an opinion. I have it here in my hand. I'm going to post it down below that says that you and I, under the Second Amendment, have the right to make our own firearms without serial numbers, thereby gutting Delaware's new so-called ghost gun propaganda term law. Stay tuned. I'll give you the details when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, constitutional attorney, best-selling author, member of the United States Supreme Court Bar, and proud American gun owner. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so, and also follow us on Twitter at fourboxes.com. We're looking to grow the channel as fast as we can. Okay, folks, approximately 1 hour ago, a federal district court in the District of Delaware, Joe Biden's home state, issued an opinion. It was a motion for an injunction brought by three plaintiffs, John Rigby, Alan Knight, and the Firearms Policy Coalition, who continues to kick butt, frankly. They brought this motion seeking to enjoin the enforcement of Delaware's new so-called ghost gun law. Now, to simplify things, because I'm trying to get this out fast, basically the ghost gun law under Delaware essentially criminalized the possession, manufacture, and distribution of unserialized firearms and unfinished firearm components, such as receivers, right? You couldn't possess it, manufacture, or distribute it. You had to have serial numbers on it and all these other rules and regulations. So the lawsuit came and said, no, that's not true, because under the Second Amendment's right to keep and bear arms, we have the right to make our own guns. And there is no historical tradition in the United States that says that in 1791 there was any bans or any kind of restrictions on the ability of an American to make their own firearms or to have firearm parts. And the judge, and I'm going to screw up the pronunciation here, I think it's Judge Noriega, Judge Noriega decided that, of course, under the Second Amendment's right to keep and bear arms, there's certain implied rights, one of which, by the way, she references the right to train, which is a case we've talked about in the past, just as an illustration to point out that there are implied rights in the Second Amendment. She uses that as an example. Then she comes back and says, obviously, if you have the right to possess guns, which is the right to keep, means the right to possess, to have, right? The right to keep, to possess, to have. And the right to bear means the right to carry. Since you have the right to keep and bear arms under the Second Amendment, you obviously have the right to make guns yourself. Now, of course, she does mention, of course, you don't have the right to sort of sell guns in the business without a license, without serialization and all that. She's like, yeah, but we're talking about the right to possess right now. So that's the bottom line, but let me give you a couple additional facts. So the plaintiff here is John Rigby and another one named Alan Knight. Basically what they both alleged and claimed, presumably under sworn declarations, that they had self-manufactured handgun that had to be removed out of state out of fear of criminal prosecution. They wished to manufacture firearms with firearm components that they owned. John Rigby owned a 3D printer with the desire and intent to use it to manufacture firearms using software code presumably, that he possesses. And likewise, Alan Knight said he owns and possesses two unserialized, unfinished receivers that are suitable for manufacture and assembly of an AR-15 design rifle. He also said he wishes to use firearm components to manufacture a firearm for his own use and not to sell to others. Again, he's saying, I just want to make guns for myself. I'm not looking to get into the business, so it's wrong to ban the possession of my component parts that allow me to make a firearm under my right to keep and bear arms. Because you have the right to keep and bear arms doesn't mean you can be forced to go buy the gun from someone, although most people do. There's no reason why you can't make the gun. There's a long tradition of homemade, self-made, do-it-yourself firearms in the United States, going all the way back to way before even the American Revolution. In making this decision, Judge Noriega in the District of Delaware points out, and she explains the standard of the Second Amendment as articulated by Nyserpa versus Brew in the Supreme Court case, which we've talked a lot about, and which my discussion in other law journals I think is important here. And what she basically explains, and I completely agree with what she's saying here, that under Heller, the first step is, does the plain text of the Second Amendment cover the conduct does it cover the conduct? And the question is, does the right to keep and bear arms cover the conduct? And she said, absolutely, the right to make guns is covered by the Second Amendment. Then she goes on to say that once you establish that the conduct or the activity that's being regulated or banned or prohibited or restricted by the government, once that's triggered, that the Second Amendment is now in play, then it's presumptively unconstitutional. You can't do it. The government can't stop you from doing it unless, she says, and the Supreme Court said this, that the government must demonstrate the burden of proof is on the government. And Judge Narioka specifically said that the burden is on the government, which is what the Supreme Court said. And so the judge here said that the burden is on the government to show what? The burden is on the government to show that the regulation they're trying to enforce, in this case, these ghost gun, do-it-yourself gun prohibitions, are consistent with the American tradition of regulating firearms in the year 1791, which is when the Second Amendment was created. Again, the reason why 1791 is important is that is the year the text of the Second Amendment was written. So if you want to understand some additional details about the scope and the meaning and the purpose of the Second Amendment and what it covered and what it didn't cover, you look at the text first, but you can also look at the history to see if there's any restrictions there. Frankly, there really weren't any. And here she said there's no restrictions on the right to make your own firearm in 1791. So, of course, you're allowed to do it today in the 21st century. Another critical thing this judge found, and this is extremely favorable to us, we've often talked about the importance of the common use test, which is that if a firearm is commonly used by Americans for lawful purposes, it's protected. It is a protected arm under the right to keep and bear arms, right? This is extremely good for us. Some people push back on me on this. It's not. It is extremely good. Why is that? Here is exactly why the common use test is good for our team. Here's why. The defendant, the state of Delaware, argued that they wanted this gun control to stand. And what was their argument? Here is their argument. Their argument was, this is what the judge says, the defendant state of Delaware has offered no evidence to support this assertion. Indeed, defendants' evidence on this point consists of a single statistic that law enforcement recovered almost 24,000 untraceable firearms at crime scenes nationwide between 2016 and 2020. That's what the defendant was arguing. Criminals use guns. That's our defense. Criminals use guns. But I told you that the common use test blows that argument up. It makes it irrelevant. Watch this get blown up. Ready? So what does the judge say to that? Although this indicates that untraceable firearms are at times used by criminals, it ignores that firearms unquestionably protected by the Second Amendment are also sometimes used by criminals. Duh! We know that. Criminals use guns sometimes. What is important is whether the prohibited untraceable firearms and unfinished firearm components are not typically possessed by law-abiding Americans or law-abiding citizens for lawful purposes. Basically, what she's saying is, it doesn't matter how criminals misuse the guns. All we care about are how do Americans who are law-abiding use the guns, and as long as they use it for lawful purposes in a common fashion, which obviously homemade guns are, boom, it's protected by the Second Amendment, and that's exactly what the judge said. Throughout the arguments that people can misuse guns, she's like, yeah, doesn't matter. We don't define our rights by virtue of how people who are criminals and psychopaths and terrorists misuse our rights. Not relevant. We don't punish the law-abiding and cost them their rights because of how people misbehave. That's what this federal district court judge said in Delaware, basically parroting the arguments and standards that I've talked about on this channel repeatedly for many, many months, even before Bruen, and of course the Supreme Court adopted in the Bruen case itself and even before. So the bottom line here, I'll just read one last thing and then I'll close because there's a lot more coming and I don't want to waste all your time today on this. But the great news is this. The statute that prohibited the manufacturing of firearms has basically been enjoined. She says the right to keep and bear arms implies a corresponding right to manufacture arms. The right to keep and bear arms would be meaningless if no individual or entity could manufacture a firearm. I repeat, this is the most important language you're going to hear today about the Second Amendment. This is from the court. Federal court, Delaware, Joe Biden state, supporting the Second Amendment. For those of you out there that say, oh my God, we're losing. No, we're not. We are kicking their butt. And there's a lot more butt kicking to come. I agree. But this is another huge brick in the wall in support of the Second Amendment on top of the others we've been talking about on this channel. I'm going to read this again. The judge said, quote, Here, the right to keep and bear arms implies a corresponding right to manufacture arms. Indeed, the right to keep and bear arms would be meaningless if no individual or entity could manufacture a firearm. Thus, if possessing untraceable firearms is protected by the Second Amendment, then so too is manufacturing them. Did you hear that? If possessing untraceable firearms is protected by the Second Amendment, then so too is making them, manufacturing them. Very big news out of Delaware. We're going to talk a lot more about this. This is putting a huge, huge gaping hole in the so-called ghost gun laws in Delaware, blows it to bits. I suspect this is the start of a precedent we're going to see in other parts of the country, and I cannot wait to be here to watch and report on the ongoing victories of the right to keep and bear arms. Okay, hope you learned a little bit something here today at the Four Boxes Diner. If you haven't subscribed, please do so, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.